PLF Supreme Court Show, joined once again by my colleagues Oliver Dunford, Senior Attorney in our Separation of Powers Practice Group, and Damien Schiff, Senior Attorney in PLF's Environment and Natural Resources Project.
Yes.
Did I get that right?
Yep.
We have a fully packed show with lots of opinions. We're rounding out this Supreme Court term. The court has issued 12 opinions since we spoke with you last. We couldn't go live last Friday. It was Juneteenth, but that didn't stop the court from issuing a few opinions last Thursday. They again issued opinions this past Monday and again yesterday. So we have a lot to get through, including, and why don't we start here, Damien, with PLF's own Supreme Court case, number 20, I believe, that we have gotten to the Supreme Court, Pung versus Isabella County. Big victory for PLF, Damien?
It's a moderate victory, I would say. The reservation being, of course, that the majority opinion written by Justice Alito, I shouldn't say not just the majority, but in this respect, the unanimous opinion of the court, was to reject our lead argument, advanced directly by our co-counsel, but whose position and our position was that when the government takes your home because you have failed to pay your taxes in a timely fashion, what is the government required to provide you as just compensation for the taking of your home, or in this case, the home's equity? So just to start off with the facts, the petitioners, the Pung family, Scott Pung, purchased a home in the early 90s in Isabella County, Michigan. He lived there for about 15 years before he died. During that period, when he lived in that home, he claimed a small deduction from his local property tax, the personal residence exemption deduction. It amounts to about $1,600 a year. In any event, after he died, his wife and son inherited the house, and they continued to live there, and it was their primary residence, and they continued to claim this personal residence exemption. They then, though, got into a dispute with the local tax assessor, who said, well, in order to claim this exemption, because the original owner has died, you need to sign a new affidavit, and that you haven't signed the affidavit for these last several years, and so you now owe these back taxes. The Pungs challenged that in state court, and they won. And the state court said, no, you don't need to file a new affidavit. And so the Pungs thought everything was fine. The problem was, in the state court litigation, they were only litigating over a few of the tax years. A new year came up, a new bill was sent, it didn't have the property on it. The Pungs thought that, well, that's going to be controlled by the state court litigation. We don't need to file another lawsuit. As it turns out, technically it wasn't controlled. So ultimately, the Pungs were dinged for not paying 1 year's taxes without this exemption. That was $1,600. With fees and interest, it ended up being $2,200. The county then foreclosed, took the property, sold it at auction for, I believe, about $76,000. And then the person who bought the house at the distress auction about a year later resold it for about $195,000, which, by the way, was more or less what the county itself had assessed the fair market value of the house at. So our argument in the Supreme Court was that, following on our win a few years ago in Tyler versus Hennepin County, when the government takes your house for failing to pay taxes, you don't lose everything. You get to keep your equity. The question is, how do you value that equity? Is it just simply whatever the government can get at this distress sale, or is it something more than that? And in fact, our argument was it should be. It should be the fair market value, which here everybody didn't dispute was $195,000, not the $76,000 that was obtained at this distress sale. As I noted at the top of this recitation, unfortunately, the Supreme Court rejected that lead argument and said that no, there is a long historical pedigree in the United States for local governments to use, and the state and federal governments to use, tax sales to foreclose on real property and then to sell that in these tax sale distress auctions. And that there's nothing intrinsically incompatible with that tradition and the just compensation clause of the Fifth Amendment. However, the silver lining in the case is that Justice Alito repeatedly stated, in a point that was amplified by Justice Thomas in a concurrence, that the tax sale is an adequate substitute for fair market value and just compensation if it's conducted fairly. And the court said, well, we're not quite sure whether, in fact, this particular auction was conducted fairly because this issue hasn't been fully ventilated in the lower court litigation. So we're going to send it back down to the lower courts to see whether they will entertain an argument that this particular sale was not fair. And I think it's fair to say that this particular sale wasn't fair, as well as explained in Justice Thomas's concurrence. For one thing, the county made no effort to see if maybe it could satisfy this paltry $2,200 debt by confiscating and selling some of the Pung's personal property, for example, like a car or a bicycle or something else much less than their personal residence. Or, as Justice Thomas noted, another problem with this sale is the lack of notice, that the Pungs did not receive actual notice of the foreclosure sale until after the period for them to pay the small debt and redeem it. Because remember, again, they thought that they were legally in the right, and they were legally in the right, but they didn't realize that they had another tax bill to pay, and they argued they didn't get adequate notice of that additional tax bill. So
yeah.
That, in a nutshell, is the short answer, Mr. Thompson, to your question. Not a complete loss, not a complete victory, but definitely quite a lot in it to really help, especially in PLF's other home equity theft cases. We have a number of these around the country where we're arguing this precise issue, which is the particular format that local governments can use to get rid of these distressed or foreclosed homes is unfair and sort of not calculated to produce a decent return. And we're hoping that Justice Alito's opinion, Justice Thomas's concurrence, will help us in ending these unfair practices.
Yeah, I don't want to, it feels a little bit like we're putting lipstick on a pig by saying like this is somewhat of a win. I mean, we can't shy away from on the QPs that the court granted cert on here. The court squarely rejected PLF's position, and I will add that this case came to the court not from PLF, but from a private counsel in Michigan who had petitioned on this issue and was granted. And given our expertise in this issue, we joined the case to try to win it. Right? We wanted to win it on this issue, but it is a hard issue to square. And reading the court's opinion, I mean, I think Alito may go out of his way sometimes to be a little bit more condescending or aggressive than he needed to be. But the one example that stuck out in my mind that was really hard to rebut, and Oliver, I'm curious how you would have argued this if you were an advocate. He puts that example in there. Imagine that you owe $20,000 in taxes on a $100,000 home. They foreclose and sell it for $60,000. Now, if we were to win, they would have to pay $40,000, the difference between the fair market value and the foreclosed sale price. And that would mean that they would foreclose on a property. They would actually lose money if the government would foreclose on it. And that's, for governments, and I don't think any of us here are big fans of it, but they collect taxes, and if people, they're not going to collect taxes if they're actually going to lose in the long run. And then why would anybody pay their property taxes?
That sounds like a feature, not a bug, but I see your point. And although I think you could argue that goes to the incentives too of the government. If the government's going to cut corners and throw together a sale at the last minute and collects only a third or whatever of the fair market value, then it maybe should come up with the rest. And as Damien pointed out, it could have gone after the Pung's car or something else. But it unfortunately, we did lose on the main question, although the fairness issue will hopefully provide some grounds for better cases. And one final point, as Justice Thomas pointed out, I mean, that I somewhat question Justice Alito's premise, which is that the taxing authority is the premise and private property is the can rebut the presumption of taxation. I don't know exactly how to draw that line, but I'm not sure enough emphasis was given to private property in the majority's opinion.
It does go to show that you need to be deliberate and intentional about crafting your QPs, right? Because if this
Definitely.
QP were crafted something along the lines of, does what Michigan did violate the 14th Amendment? I think you could see Alito's opinion becoming the opinion of the court, because you know, even Justice Sotomayor wrote a separate concurrence to say nothing in Alito's majority opinion speaks to the procedures employed here. So you could see a different QP on this very same set of facts being a complete win for the Pungs. But on the issue that the court granted cert on, which was the QP that was written, is fair market value required as just compensation? The court was not ready to go that far. I don't think they want to countenance tax scofflaws. I think Alito made that pretty abundant in his majority opinion. But you know, I don't think that's what the Pungs were or are. I think they've been quite railroaded in this procedure, and hopefully there is silver lining here. This case is not over. I will say, insofar as when the PLF got involved, there was no. I mean, if the Sixth Circuit opinion stands, the Pungs are done, and they lose everything. That's not where it's at now. It's got remanded back to the Sixth Circuit. They can still prevail here, and we're going to continue fighting for them. But you know, it's a disappointing decision from what we had advocated before the court.
Yeah. Has anyone thought about why the court took this case? You know,
Damien has some thoughts on that.
I do, although I could go back to that hypothetical you mentioned, Mr. Thompson, about Justice Alito's hypothetical, I should say, about the local government taking laws. Theoretically, yeah, that's possible. Though, as I recall, in Tyler, I think one of the arguments that the government made to defend itself there was that on balance, it loses money anyway. Or not loses money, but that on balance, it doesn't get back all of the tax debt that is owed to it. That oftentimes these houses are so distressed that their fair market value is less than the tax debt owed. So if you credit that, then it sounds like this theoretical injustice, if you want to call that, for the local government in that case is probably just that, theoretical. As far as why the court took it, what Mr. Dunford was suggesting, I think that perhaps the court thought there was more play in the QPs than in reality, because around the same time the court granted cert here, we had cases at PLF that were more or less asking the same thing, but in a more capacious fashion that would have allowed perhaps these off-ramps about how, well, maybe not always fair market value, but perhaps you need to have additional protections in the sale. And I think the court I think the cert pool or whoever it was, just fixed upon this because the facts of this case are really egregious. Now, it's funny, they don't really come out that much in Justice Alito's opinion, but they certainly do in Justice Thomas's opinion. And if you recall listening to the oral argument, more than one justice noted, I think this is even why Justice Barrett brought up Les Mis, because it seemed like there was something pretty radically unfair going on in how the county treated the Pung. So I think that might have been it. The court thought, okay, these are all more or less presenting the same issue. This is the best facts, we'll take this. And then maybe afterwards they realize, oh, yeah, perhaps the way this has been presented maybe doesn't give us as much room, and so maybe we'll just make a very narrow decision here and see what happens in the lower courts.
Yeah, I think that's fair. Well, we got a lot more to get through. Let's move on to guns, Second Amendment. We have two cases that were decided recently on this issue. Oliver, why don't we start with Hermani?
Hermani. U.S. v. Hermani. Ali Hermani was a dual citizen of the U.S. and Pakistan, born in Texas. The government apparently thought that maybe his family was involved in terrorism, so they came to the house.
Stop for a second, Oliver. Are you getting the feedback here, Damien?
No.
Yes.
Oh, damn it. I can't do anything. I have one microphone. You get feedback?
Yeah, you know, it's more like you're unsynced and you're in and out.
I'll leave and come back.
Okay. Damien, why don't you start us off with the other Second Amendment case? That's Wolford.
Was I assigned this case, or?
I believe you were.
Really? Okay. Well, I don't. Wolford challenged to a Hawaii law, which was enacted in the wake of the Supreme Court's Bruin decision, sort of a landmark Second Amendment decision, adopting a pretty strong originalist understanding of the Second Amendment. Anyway, in response to that, Hawaii enacted a law that sort of changed the common law property default. So the common law default is that you have the right to exclude. That's more than a default, that's a fundamental thing. But if you, a private property owner, open your property up to the public, then that's sort of a constructive authorization to anybody to come on, and that to negate that, you then have to affirmatively do something. So, for example, you don't want people coming into your restaurant without shoes or shirt. You have to then put up no shirt, no shoes, no service. Otherwise, it's not considered a trespass. Well, Hawaii changed these defaults just with respect to gun owners, or more specifically, those who are lawfully carrying guns on their person. The law said that you can only go onto otherwise publicly open property with a gun if you already know that you're authorized, and if there's some sign. And of course, gun owners were very much dismayed by this, because there are a lot of people who operate commercial properties in Hawaii who don't really have a problem with gun-toting customers, but for optics or for other reasons, they don't really want to, put up a big billboard and say, "You got a gun? Come right on in." So de facto, this made a good portion of the public areas of Hawaii basically foreclosed to those who were otherwise lawfully exercising their Second Amendment rights. So the lawsuit was filed challenging this property law default change, and the lower courts ruled in favor of the state on the theory of sort of the aloha spirit, that Hawaii has a different tradition. Hawaii has a very strong tradition of not liking weapons, handguns, and that the sort of background principles of property law are such that it might be harder to tote your gun in Hawaii, but that's just simply the nature of the Hawaiian state. And the Supreme Court took up the case, and in an opinion authored by Justice Alito, goes through the steps that the Bruin decision articulates. First step is, does the activity fall within the plain text of the Second Amendment? Basically, nobody said it didn't. But the second step was, is there an historical analog that would otherwise justify Hawaii's change? And Justice Alito said, no, there isn't really one. That there is some reference to, well, old hunting laws, but he distinguished those because hunting was sufficiently different from just simply going onto private property that's otherwise open to the public. And also there was some discussion about how some of the particularly invidious black codes right after Reconstruction that tried to disarm newly freed slaves, that somehow that was a precedent that authorized Hawaii. The majority opinion gives that short shrift as well. So all told, a big win for gun rights. Interesting to see how it affects our property litigation, because obviously here at PLF we don't have a Second Amendment practice, but we do a lot on property rights, as just witnessed by our discussion of the Pung case. And so I'm still trying to figure out, and our property rights litigators are looking at this right now, how this affects our other work, especially on the right to exclude, which you, Mr. Thompson, are very intimately familiar with, having successfully vindicated the right to exclude in Cedar Point.
I had the same thought, and that's, I guess, where I want to go is what Hawaii did here is they changed the default property rule to say the default rule is that you have to give affirmative consent to allow for gun owners to come onto your property, or gun possessors, or if you have a gun. And looking back at Cedar Point, one of the issues, it didn't really come up, I mean, it was sort of at play a little bit, is why would this be a taking? Cedar Point dealt with trespassers on union trespassers on private property. If the default rule is they can come onto agricultural property, then we're not taking anything. That's sort of just the background principle of property law in California. Ergo, it can't be a taking. And this is not really fully fleshed out, at least at the time, in my property law understanding lived and died with Cedar Point. So at the time it was, these background principles are largely a function of state law. But in Cedar Point, the court did say that there are sort of federal backstops on what states can do to private property. And this seems to sort of back that up by saying, yeah, Hawaii can't, as a property matter, change the default rule so dramatically so as to disenfranchise individual Second Amendment rights. And I think that speaks well, or speaks highly of sort of future attempts by governments to, quote unquote, change background principles in order to achieve some government end if it's infringing on the individual property owners. Oliver, what do you think?
I agree. I think the decision obviously is correct. The notion that if you can carry it everywhere, except in places like this, unless they give the affirmative consent, just makes no sense. It's kind of in one respect, the public accommodation laws here come host somewhat to those who favor gun control. But if there's a right to carry, there's a right to carry, and that should be the default. Again, this kind of goes back to our discussion on property versus taxes. The default is private property and private rights, and the exceptions have to have the burden of being established.
It's also important to note, though, that nobody's denying that a private property owner can say no to somebody with a gun, right? So in that sense, the right to exclude is not really being, it's more of, again, we're talking about these defaults. And in that respect, this Hawaii law kind of cuts both ways, because it does, in a sense, kind of infringe the property rights of those people who open their property to the public who don't have a problem with gun owners. It makes it harder for them to vindicate that desire, because they then have to go out and actually post a sign or otherwise say, yeah, come on in. Whereas under the prior rule, they could achieve that without going to that extra step. So just from the property rights angle, I think it cuts both ways. But I think what really irked the majority here is that it did seem to be a law that was sort of almost like animus against the Second Amendment. That it was because this, I think Justice Barrett's concurrence does a really good job of explaining kind of why the supposed analogs that the government offered here weren't really adequate, because there was no argument that somehow if you're necessarily carrying a gun that makes you unsafe. And there wasn't, whereas these laws prohibiting hunters from coming onto the property, they were designed in particular to limit those instances where there might be active hunting going on and there's a risk of injury or property damage. But here, this is sort of a blanket rule, and it would be just like kind of saying, well, we're going to change the property defaults if you're a Republican. So I think there was that almost equal protection concern about how limited this property right default change was.
That's a good transition to Hermione, although I want to mention one more thing, the dangerousness component, which was relevant in Hermione. But I do think that Wolford is important for sort of reinforcing Bruin. I think Bruin, especially after Rahimi, some were wondering how prevalent this sort of historical analogs test was going to be going forward. But the court here clearly does not shy away from Bruin, jumps full-fledged back into the water. And frankly, I'm not clear on Bruin myself, and I think Justice Jackson, for all the ridiculousness of citing the black codes, has a point in that it is part of our historical tradition that people disenfranchise as a Second Amendment matter individuals, although the laws were unconstitutional for other reasons. It is part of the tradition. Why are those laws not considered? It's unclear to me where you draw those lines on what laws are considered and what laws are not considered as a matter of historical analogs. It's not I don't think it's as obvious as sometimes the majority makes it out to, but that's the standard we're in. And now that I've killed the beautiful transition Damien made, let's turn to Hermione that deals with pot and guns. There we go. Oliver.
All right. This case involves a statute that says that an unlawful user of or someone addicted to a controlled substance cannot own handguns. And cops showed up at this home of Ali Haman and his family. The government apparently suspected the family of terrorism. Ali Haman was born in Texas, but he was a dual citizen of the United States and Pakistan. As the majority opinion says, he was very accommodating. He let the cops in, search. Apparently, during the search, admitted that he used marijuana every other day. So I don't know. He may be a citizen of Texas, but he should not be talking to the cops. But a month or so later, he was indicted for violating the statute. He challenged it on Second Amendment grounds. And Damien pointed out the test which the court applied, and the government cited 3 statutes that it said were analogous enough to the modern statute that justified the law: vagrancy laws, civil commitment statutes, and the last one is surety laws, apparently under which judicial officers could compel habitual drunkards to post surety bonds to ensure their good behavior. Government rejected each of those analogies and said that the convictions violated the Second Amendment. And it was a unanimous to the judgment. Justice Thomas concurred and said he believes that as an original matter and based on the court's precedents, that the statute violates the Commerce Clause, obviously setting up some future cases. Justice Jackson agreed, but she criticized Bruin. And then Justice Alito concurred in judgment with Kagan and just said, somewhat interestingly for Alito, especially considering his law and order reputation, a well-earned law and order reputation, he says that marijuana has become more accepted recently. And there was no evidence in this case about, although Mr. Hamani admitted to using marijuana, there was no evidence about how much he used every other day, the strength, etc. And he said, so in that instance, the laws that would have applied, or that the use of marijuana is like the use of alcohol at the time of the founding. And so he agreed, but he said he would have gone no further than that analysis. So another good ruling for the Second Amendment. And even the progressives agreed.
I wonder, like, if one uses stronger and more frequently marijuana, does that make it more or less likely that they should be able to carry a gun? I mean, probably just going to be melted into their sofa at home. I thought what I thought is important about this case is that the court seems to really be turning towards dangerousness as the standard for when you can dispossess people of firearms, and that's come through now in a couple of cases, and it just feels like at least those of us who are a little bit uncomfortable with Bruin, I can get a little bit more comfortable with sort of a dangerousness standard that seems a little bit more objective to me and also tied to a historical background. Damien, anything to say about Hermione?
Nothing to add to Oliver's excellent recitation.
Well, Oliver, who mostly had a good microphone during that recitation, let's see if you can keep it together for a discussion about immigration, which we had 3 cases that dealt with immigration. Oliver, there were 2 with the same petitioner, Mullen. Which one do you want to talk about first?
Let's go with the less controversial one, although still controversial, the Mullen v. El Otro Lado. This case involves people who are coming to the United States and petitioning for asylum. And once somebody gets in the country, there are certain procedures that the government is supposed to follow. And the statute at issue says that a non-citizen who arrives in the United States.
All right, Oliver, I'm going to have to kick you out again and ask you to re-enter. I will talk about the third immigration case, and this is Blanche. This dealt with lawful permanent residence, which is a status of immigration for people just below citizenship. And what the court did in this case, or what the lawful permanent resident had been, I guess not convicted, but arrested for counterfeiting, I believe it was, before he left to go to China. Upon his return, typically the standard for letting is lawful permanent residents just get to sort of breeze by the immigration kiosk at the airport, but because of his prior arrest for counterfeiting, the immigration officials at the border paroled him, which is different than just allowing him to enter, and later initiated deportation proceedings based on his counterfeiting. So the issue was, what standard do those border officials need when someone comes in, do they need clear and convincing evidence that they had committed a crime? Do they need to be proven guilty? What is the standard of proof that would allow them to not just let them in naturally, which is the default rule? And the court said they do not need clear and convincing evidence, that what the border agents did here was okay, and that they can parole him and seek to deport later. This does seem to me to be the most easily understood rule. I think if you require sort of certainty or a heightened standard at the border, it's going to be pretty hard to administer, because these border agents, you can just imagine, they don't have full information. They're never going to have full information, so it would largely render any arrests a nullity. At the same time, as somebody who's, policy-wise very much in favor of immigration, I think it's difficult to understand why the court is creating such different standards for citizens and lawful permanent residents when they are supposed to largely be treated synonymously. But any thoughts on this case, Damien, Blanche, or Oliver, before we see if we can hear from you?
My general position is I'm against counterfeiters, whether lawful permanent residents or citizens.
So can we deport citizens then if they're lawful?
Unfortunately, no, that's not permitted.
But you would be pro deportation of counterfeiters as a policy matter. All right, Oliver, let's try you again, buddy.
Okay, let's try again.
There you go.
All right, good. All right, this case involves people who arrive at the border, at or near the border, seeking asylum, basically. So the statute says a non-citizen who arrives in the U.S. and seeks admission may apply for asylum, but if the person shows up without travel documents, then the immigration officer shall order this person's removal unless she conveys the intention to apply for asylum or fear of persecution.
It's not working, Oliver, buddy. I'm sorry.
I'll sign off. Good luck.
Thanks. Damien, it's me and you. What do you know about the Mullen cases?
I believe it involves the temporary protected status. I think that's the acronym, the TPS status, which is a designation that the president has the ability to make so that those persons who are in this country but can't reside here permanently nevertheless can stay here, at least on an interim basis, if their home country is designated as a particularly, layman's terms, dangerous place to go back to, either because of some natural disaster or civil war or strife or what have you. And the current administration has sort of taken a general policy view that these designations, we have too many of them, they've gone on for too long, and I think it's basically trying to eliminate all of these designations, which then results in the deportability of a number of people. And in these cases, I believe it focused in particular on Syria and Haiti. Now, the main question in the case, and one that I think is of interest to people who practice in administrative law generally, not just immigration, is the question of judicial review. Because the relevant statute that governs this DPS status says that, paraphrasing, no judicial review of the quote, determination to revoke TPS status. And the question is, does that mean all challenges to the determination are judicially barred, or just certain types of challenges? And the lower courts here said it was the latter. And the lower courts made a distinction between challenging the ultimate decision and challenging certain procedures that may not have been followed. So in this case, for example, the petitioners were focused, or the respondents were focused in particular on how the Secretary of Homeland Security had allegedly not appropriately engaged in consultation with the Secretary of State and other federal agencies as the statute requires, and other procedural defaults that were allegedly committed. And their argument was that's different from the final determination of whether to revoke this status for Haiti and Syria. Mm-hmm. The majority opinion by Justice Kavanaugh said, no, you can't really divide it up that way. That determination in this statute is pretty broad, and especially here where the procedures that were taken that led to the final result are really sort of, it's a unified administrative decision process. And so the court said on that, sorry, judicially barred. On the constitutional question, the really nobody doubted that even with this statutory bar, you could still bring a constitutional challenge. And here there was a constitutional challenge under equal protection that the Trump administration had eliminated, in particular, the status for Haiti on racial animus grounds, and citing a number of comments made by the president and I think by the Secretary of Homeland Security, maybe others, that that allegedly supported that animus. And on that point, the Supreme Court on the merits said, no, however distasteful we may find the way these comments were phrased, they are nevertheless, in substance, essentially non-racially motivated. They're either about how civil strife is bad in certain countries, or about how we just don't want a certain level of immigration, but that the court said, look, this administration basically doesn't like this status for anybody. It's not just simply a matter of Haiti. It's just effectively a non-immigration policy, and whether you like that or not, it's not really racial, no equal protection problem, so the case is over.
Yeah, I guess I haven't fully read this opinion yet, so I'm just basing it on what you have resuscitated there. I'm curious, and I will go back and read it, and if you know this question, to what extent, is the court saying that, there were maybe some racial motivations, but that it could also be explained through these other means? Is immigration unique? Or if race plays a part, could that affect the constitutionality of it if there are other non-racial reasons?
I'm trying to recall, I think the court said it was assuming without deciding that a heightened Arlington Heights standard would apply. I believe the court said that, and nevertheless, even with that heightened standard, still went against the challengers. Justice Alito said that none of the statements was, quote, overtly racial. And then the question is, well, could some other racial animus be implied from the statements? Now, this is, none of the statements was quoted in the majority opinion. So it's not as if there's a, line-by-line analysis. But,
right.
But the summary conclusion is that, setting aside the vitriol or the hyperbole or the name-calling, that in substance they're either arguments against poverty or they're arguments, against the idea of immigration, but they're not really, or arguments against crime, but they're not really arguments against.
So it is examining the statements and determining as a factual matter whether they are racially motivated statements.
Yeah, yeah, but certainly in a generalized fashion, because again,
Yeah.
there isn't a line-by-line analysis.
Now, Damien, can I also rely on you for the other Mullen case versus Otro Lado?
Yes, that was the one I believe that Oliver was trying to recite before he was conquered by static. This is a pretty straightforward case where there was a change in the law in the mid '90s to the to our immigration regime that allowed a certain sort of expedited processing for asylum seekers who have, quote, arrived in the United States, as opposed to people who are already physically present. So the statutory phrase was, if you have, quote, arrived in the United States, then you're entitled to a certain type of expedited asylum seeking processing. And in the waning days of the Obama administration, a lot of our land ports were sort of overwhelmed by people who were seeking this expedited processing. And so starting with the Obama administration and continuing through the Trump and Biden administrations, a certain, quote, metering went on, whereby the U.S. immigration officer would stand outside of the land port, basically on Mexican territory, and say, sorry, we've reached our occupancy physically in the building right now. We can't take any more right now. Come back tomorrow. And so the argument was, well, if you were one of those people who were front in line but you didn't get inside the building, are you still entitled to this processing? Have you arrived in the United States?
Right.
The Ninth Circuit said, yes, you had, and the Supreme Court, in an opinion, again, I believe authored by Justice Alito, if I'm not mistaken,
Yours, yep.
said, no, you haven't. That basically the plain meaning of the phrase is that you have to be in the United States if you, and he goes through a couple of examples that, if you knock on somebody's door and they slam the door and lock it, you wouldn't say you've arrived in the house. So, and of course he cites other parts of the statute that use different terms like have you reached the border? Have you arrived at the border? Other phrasing that suggests that Congress knows how to make this distinction. It's an interesting opinion for statutory interpretation generally, because he talks about the superfluity canon. This is the idea that we don't like to interpret statutes so that there's duplication. And admittedly, there is some duplication here because there's already a provision that says that you're entitled to this expedited process if you're, quote, physically present in the United States. And the argument is, well, if you've arrived in the United States, you're necessarily already physically present. So to give arrived in the United States separate meaning, we have to say it means not actually crossing the threshold. And Alito says, well, you know what? It's just one canon, and in this case, it's overwritten by other canons and by what we consider to be the ordinary meaning of in the United States.
Yeah. Yeah, so there are textual arguments that go both ways. The court chose one, and if I think with all three of these immigration cases, if you don't like the result, there's nothing constitutional about any of them. You can go change the law at Congress's level, and I think the court would be okay with that.
Yeah.
Well, we've gone through Pung, we've gone through guns, we've gone through immigration. We have still a number of cases to get through, including the ones that Oliver was supposed to do. Let's put a timer up here, Damien, see if we can't get through each of these cases in less than 5 minutes. Let's start with Monsanto, which was a case I know that you were following pretty closely.
Yes, a lawsuit brought by a gentleman in Missouri who argued that his use of Roundup, which is a common pesticide, herbicide marketed by Monsanto, led to his developing cancer. And so he brought a products liability failure to warn claim under Missouri law. He won a judgment, and Monsanto then sought review in the Supreme Court, arguing that no, this Missouri judgment is preempted by federal law. Federal law provides a comprehensive regime for how you market and label herbicides and pesticides, and EPA specifically reviewed the cancer risk of Roundup, said, no, we don't think it's credible. And so it issued approval for our herbicide with an approved label with no mention of cancer risk. And if we hadn't followed that strictly, we ourselves would have been liable under federal law. So that means that any obligation.
Rock and hard place.
Yes, that means any obligation under state law that would require us to vary from this federal standard would be preempted. The majority opinion written by Justice Kavanaugh, he agreed. And it's kind of a ho-hum case because, in this sense, because the dissent by Justice Jackson, joined by Justice Gorsuch, doesn't really disagree with the idea that, well, federal law did require that you had to follow the label, that you're right, be preempted. But they concoct this, I think, kind of strained idea that, well, these statutes and regulations from EPA don't actually require that you follow the label. You can kind of vary from it so long as you're just sort of generally being consistent with the idea of avoiding harm to the consumer. Kind of a weird argument when you think that EPA itself has said, no, this is our regulation, this is how we interpret it. And all the regulated public apparently has always thought that, no, we have to follow this label, otherwise we'll be criminally liable. So yeah, kind of a weird case. I think it gets the right result. Interestingly, Justice Thomas concurred to say, hey, nobody's raised some other constitutional questions like, where does the federal government have the authority to regulate pesticides like this that aren't in interstate commerce? And secondly, I think maybe FIFRA violates the non-delegation doctrine, because how can Congress give EPA the authority to just dictate whatever it wants to on these labels? So that was a solo concurrence, but that was an interesting digression.
I mean, how is Roundup not in interstate commerce? I don't understand.
Well, his argument is that the relevant activity here was the use by the particular plaintiff, and he was just using it, or he was exposed to it just in a business in Missouri that wasn't involved, I guess, in any immediate interstate activity.
So so he's saying FIFRA can't reach that action?
He's basically saying Wickard is wrong. You know, it's like that if you just use a pesticide on your own property, then that activity, even though it might harm you, that's not an action in interstate commerce.
I mean, would the upshot of that be that that individual then could bring a challenge to the cancer? Yeah. All right.
Yeah, exactly. Yeah.
Well, I'm all pro getting rid of Wickard.
Yeah.
Well, let me talk about Landor versus Louisiana Department of Corrections. This is a case that came to the court with pretty awful facts. A Rastafarian who religion required him to wear his hair long was put into the Louisiana prison system. He brought with him a copy of a Fifth Circuit decision saying that they were not allowed to cut his hair based on religious reasons. The prison officials took that judicial opinion, threw it in the garbage, strapped him down, and shaved his head off, contrary to his religious wishes. He was subsequently released from prison and brought suit for damages, arguing that this violated his constitutional rights under RLUIPA, the Religious Land Use and Something Act. And because he couldn't at that point seek injunctive relief, he had been released, so the only remedy he had for this egregious, which I think everybody admitted was egregious behavior by the prison officials, was to seek damages against them. The Supreme Court, in a 6-3 opinion by Justice Gorsuch, I believe, says that you cannot seek damages against individuals under RLUIPA because RLUIPA is spending clause legislation, and those prison officials never consented to the conditions that RLUIPA puts on them. So it's a straightforward contract analysis, and I can remember the oral argument in this case when Justice Gorsuch was really talking about these sort of contractual Baylor, different contractual terms that you hear in your law school contracts class, and that these third parties, these prison officials, aren't the ones contracting with the federal government to receive federal funds. Instead, that is the Louisiana Department of Corrections that is making that contract. And so, yes, they are subject to RLUIPA's damages provisions, but because it's spending clause legislation, that does not reach these third parties who are employees in their personal capacity. which is what the lawsuit sought. It's an interesting case in that I think it puts some limits on causes of action for statutes that rise under the spending clause and distinguishes pretty squarely between RFRA, which was a commerce clause, and I think 14th Amendment legislation that, that's the dissent's principal point, is that the language in RFRA and RLUIPA are identical. In one of them, we already have said that we allow damages to be sought against individuals in their personal capacity. In this other one with the same language, we're saying it doesn't. That doesn't make any sense. And Justice Gorsuch says, and the court says, it does make sense because the spending clause is different. This deals with money. It deals with who's contracting and who's accepting the responsibility. That's the state. It's not their designees. They haven't signed anything and they haven't consented to anything. So it's an interesting spending clause decision. I think it will. My sense is this is the first and maybe multiple spending clause decisions to come down. Maybe the court is looking at this particular clause and wants to constrain Congress in ways or constrain lawsuits in ways. But I get the sense that this is the first in more spending clause cases to come.
From your mouth to the justice's ears, I certainly hope, because as you know, Mr. Thompson, we here in our Environmental Natural Resources section of PLF have been litigating some swamp buster cases for some time. Swamp buster is this program under the administered by the United States Department of Agriculture for various farm programs. And it's a spending clause measure that allows the federal government basically to do a lot of traditional land use regulation by getting farmers to condition their involvement in these farm programs on allowing all of these wetlands to be preserved or other limitations on how they use their property. So I welcome the court's increasing skepticism of the spending clause. I particularly liked, I didn't know the history about how apparently Governor Morse, who was a big fan of the spending clause, tried to insert a semicolon, or maybe it was a comma rather than a but it was a punctuation change that he tried to insert at the very end of the convention to get the spending clause to be interpreted more broadly. And then I think it was Roger Livingston or someone else who caught it and then nixed that. So I thought that was
yes. Well, that's Landor. Damien, Hunter, what's Hunter about?
Hunter, interesting criminal procedure case concerning the extent to which a criminal defendant can be held to the bargain of having waived his appeal rights. The case arose out of I believe it was a fraud prosecution, and the defendant Hunter was subjected to, I think, 8 or 9 counts that could have led to like 300 years in prison or something like that. He negotiated, plea bargained with the prosecution to go down to 1 count, and I think it was maybe 5 years in prison. But one of the things he had to give up was his right to appeal both the judgment and the sentence, unless the sentence was either beyond the statutory maximum or if he had some inefficient or inadequate assistance of counsel claim. Otherwise, he would waive it. So it was accepted by the district court, but this was all done. This all happened before he had the sentence. And one of the things that ended up being in the sentence was, on his supervised release, he had to agree to medication, psychiatric medication. So he wanted to appeal that and say, compelling me to take medication, psychiatric medication, is a violation of my substantive due process rights. And the Fifth Circuit, unlike most circuits, has a very narrow standard for when you can undo a plea bargain waiver, appeal waiver. And the Supreme Court took up the case and said, no, we think the Fifth Circuit standard is too narrow. We think that it should be a little more generous. We're going to call it the miscarriage of justice standard. And basically, Justice Kagan's majority opinion talks at length about how this is not anything goes, but it's not never. We do think that there are times where, not so much because of the rights of the defendant, but this is what I found very interesting, because of almost sort of the dignity of the judiciary itself, that it would sort of impugn the integrity of the judicial system if we were to actually abide by some of these appeal waivers. And one of the examples that came up a few times was, what if ultimately the sentence is selected by an orangutan who pulls the sentence out of a hat?
Right.
Wouldn't that reflect poorly upon the judiciary if we were to observe that? So anyway, the court said, miscarriage of justice is the standard, remanded to decide whether that is in fact met here. What I found really interesting was the discussion between Justice Barrett and Justice Thomas about whether the U.S. Supreme Court has a general, quote, supervisory power over lower federal courts, which is an issue that I wasn't familiar with, but a very interesting issue. The argument being that unless there's a particular statute or a constitutional provision, the Supreme Court has no power to review what lower courts are doing, and that the standard for appeal waivers. Mm-hmm. Justice Thomas said this was discussed in the Federal Rules of Criminal Procedure Committee a few years ago, and they said no, we don't want to add the rule. Okay, so how are we now, Supreme Court, stepping into the void when Congress has set up this process for these rules, and the committee's saying no, we don't want the rule, and now we're kind of producing a rule that seems like we're acting in some sort of inherent power, but do we even have this inherent power? So anyway, very interesting collateral issue.
That is interesting. I haven't had a chance to read that one yet, but I'll get to it. I want to talk next about TM versus University of Maryland Medical System. This was one of the few 5-4 opinions in this court, and I think that's the most interesting thing about the case, frankly, because this case concerned the Rooker-Feldman doctrine, which is I don't know if we're going to call it an extension doctrine, but a doctrine that says that courts, the federal courts should not hear cases that have been decided in state court. And the issue was, does that rule only apply to cases that have been ultimately decided by the state Supreme Court, or at least have reached its final resting place? Or does it also apply to cases that have reached decision at sort of an earlier stage? And what happened here, TM was put in a psychiatric ward and was given medicine or some sort of prescriptions against his or her will. I think it's against her will. She ultimately got released from the ward on certain conditions, and a consent decree that allowed her to get out, but then she brought suit while that case was still in the state court system, challenging what they sort of the mandatory incarceration, for lack of a better term, in the psychiatric ward. And there was still a state court case pending in the Maryland Court of Appeals. So the question was, does Rooker-Feldman essentially apply to this scenario where the case had not been fully resolved in the state court system, but that she is alleging violation of constitutional rights, which federal courts otherwise have jurisdiction to hear in the first instance? The court, and again, a 5-4 opinion authored by, I believe, Justice Sotomayor, held that Rooker-Feldman does apply to this scenario. And I think that was a surprise to most court watchers who thought that the Rooker-Feldman doctrine was sort of going to be reserved to Rooker and Feldman, two cases that had established the doctrine. But no, the court says that Rooker-Feldman also applies to these scenarios where you're trying to reopen or challenge an existing decision, even if that case has not reached its final resting place, and thereby denied her the right to pursue this case in federal court. The breakdown of the case was really interesting. You had your typical ideological lines not followed whatsoever. Sotomayor delivered the opinion, joined by Thomas, Alito, Kavanaugh, and Jackson. And the dissent was written by Justice Barrett, joined by Roberts, Kagan, and Gorsuch. So interesting lineup, interesting decision. It's obviously a hotly contested issue that I think could have gone either way. In 5-4 opinion, we now know that Rooker-Feldman applies not just to decisions at the final stage of a state court proceeding, but also to decisions and judgments that are at interim stages of state court proceedings. I have one more Oliver case on my list. Damien, do you know anything about the Cisco case?
Yes, that was, I know because I remember I covered it for the oral argument. That was the Alien Tort Statute case, where the argument is a number of Chinese practitioners of Falun Gong brought a lawsuit against Cisco, arguing that they were tortured in China for their religious beliefs, and that torture was sort of made possible through, I think, some sort of like surveillance or other technology that Cisco developed. Cisco, an American company that had developed here in America.
Mhm.
And so it was basically a tort statute seeking recovery of damages against Cisco executives and the company. And the Alien Tort Statute, it's an enigma. It was passed, I think, by the first Congress, but then lay dormant for almost 200 years. In more recent years, it's become active in the lower courts, and the Supreme Court, in a case called Sosa a few years ago, said that, well, we recognize that the Alien Tort Statute is just a jurisdictional statute, but it might have some causes of action that you could take advantage of, and maybe even the Supreme Court itself, we could create a new cause of action. And so the issue was whether this cause of action door that was left ajar in this prior case, whether it would stay ajar, be open further, or slam shut. And Justice Barrett, in her majority opinion, using the same metaphor actually of the door, said no, it's slam shut. We basically decided that there's no way that the judiciary can come up with new causes of action concerning torture or other international crimes that would not have foreign policy complications. And we've already said we don't want to have foreign policy complications, especially here. Look at this. This deals with China, you know. So basically, any liability against Cisco is going to have to involve allegations of pretty bad conduct against high Chinese officials. So no, we're not going to do it. The court doesn't slam the door entirely shut, because it does say the quote Blackstone three, the three traditional international torts that Blackstone himself recognized. I think it's like torts to ambassadors, violations of safe conduct, and piracy. If you can get those three, you're good. Otherwise, no good. And there's also a statute that Congress passed concerning torture, and the plaintiffs here argue that, well, we can fit under that statute, even if the Alien Tort Statute doesn't apply. We've got this new statute. The court said, sorry, that new statute doesn't cover, quote, aiding and abetting liability, and your whole tort is based upon Cisco's aiding and abetting the Chinese, so no recovery there either.
Interesting. What do you see as the long-term effects of this case?
Well, I think it will basically eliminate this entire, this sort of plaintiffs, kind of specialty plaintiffs bar practice.
Yeah. Well, we got one more case by my count that we need to discuss that came down, and that's ExxonMobil versus Cymex. This is the second case this term, I believe, that dealt with when Cuba, the communists took power in Cuba and seized power. You remember a couple weeks ago we were talking about a case, I believe, with the cruise ship liners.
Cruise, right?
Yeah,
interesting. Justice Kagan dissented in both of these, so she's a big fan of Fidel, I guess.
Well, yeah, this case concerns Cuba seized Exxon's refinery terminals, packaging plants, what have you. And when Castro came to power, the Helms-Burton Act gives U.S. nationals the right to bring suit against anybody trafficking in those confiscated assets. And the defendant, so it's pretty clear on its face, and presidents in the past have suspended the Helms-Burton Act, but President Trump in his first term, I believe in 2019, lifted that suspension, making it, and I think the next day Exxon Valdez brought suit against Cuba, saying that they were trafficking in their stolen property. Cuba said, essentially, yeah, but we still have sovereign immunity, regardless of what Helms-Burton says. I mean, you may have a cause of action, but that doesn't waive our sovereign immunity. So the issue was essentially that, is sovereign immunity apply here, or has it been waived? And the court, in a 6-3 opinion, says Helms-Burton itself abrogates the Cuban agency's sovereign immunity. Justice Kagan, in dissent, says you're collapsing both cause of action and sovereign immunity. Typically, we require sovereign immunity to be expressly waived by statutes. That's been a point, at least in a number of court decisions recently. Justice Kavanaugh, in his 6-3 opinion, says, well, I mean, it's pretty hard to come to waive it any more than granting a cause of action against the very entities that otherwise would have sovereign immunity. So that's the dispute here. The court allows this suit to go forward, so it'll be interesting to see what happens now in these lawsuits against appropriated property in Cuba, how the Cuban government responds to that. But the court does say, sure, there are foreign policy concerns here, and there is an escape hatch. The president can always suspend it like he did before, or she did before, and well, that's the fail-safe if there are foreign policy concerns.
Yeah, I think the big distinction here from the Cisco case we're just talking about is here there's clearly a cause of action, right? Congress has said we want this to be actionable. So if that's true, then it's different from in Cisco where basically the court's being asked to create the cause of action. Also, too, the Foreign Sovereign Immunities Act, which Justice Kagan relied upon, it's all pertaining to activities in the United States, foreign sovereigns' activities in the United States. But the whole point of Helms-Burton is we want to give a cause of action to what they did to us in Cuba, not what they did to us in the United States. So it just on its face seems to be a statute that's not particularly relevant.
Well, Damien, we did it. I don't think we need Oliver anymore. We'll just excise him.
I think we're good, yeah.
We'll just excise him in the future. Thank you. I mean, that was 13 opinions. We have some exciting ones still to come, including birthright citizenship, the transgenders sports policy cases, the removal cases, the election day case. Any more that are on top of your mind?
No, those are the three that, immediately come to mind as well.
Yeah, mail-in voting. Well, with that, I have a very brief trivia question for you that I think you'll nail. Do you know which Supreme Court justice celebrated his or her birthday yesterday?
Oh. No, it would just be a random guess. I have no idea.
Well, it was Justice Sonia Sotomayor. We wish her a happy birthday here at PLF.
Yeah, very
and
good.
With that, I will ask who are the two oldest and the two youngest justices?
The two youngest are Barrett and Gorsuch. And
Wrong.
Wrong?
Wrong.
Oh, sorry, Jackson and Barrett. Sorry,
there you
Jackson and Barrett. Sorry, Jackson and Barrett, yeah. The two oldest are Thomas and Alito.
Thomas and Alito, that's right.
Yeah.
And how many justices in their 50s?
Kavanaugh, Gorsuch, and I think Barrett now. Is that right?
Well, Jackson.
And Jackson is in her 50s as well?
Well, you just said Jackson was the second youngest.
No, she is the youngest, but...
No, she's the second youngest. Barrett's the youngest.
Ah, okay, I didn't know that. Okay, so then four. All right. Very good.
Barrett's the youngest, Jackson, then Gorsuch. Mr. Kavanaugh, Justice Kavanaugh is in his 60s, along with only one other justice.
Kagan.
And then we have four justices in their 70s.
Very good, okay.
Happy birthday, Justice Sotomayor. And with that, we are excited to be back next week. More opinions to come. Hopefully Oliver will have a mic if we don't fire him completely. And we'll look forward to telling all of you about the latest Supreme Court opinions. With that, Damien Schiff, thank you for joining me on the PLF Supreme Court Show. And until next time.